Hi, my name is Arati Ganeshan, and I'm here with Medianama's editor Nikhil Pahwa to discuss Twitter's recent failed challenge at the Karnataka High Court. If you remember, last July, Twitter had challenged 39 of the Indian government's blocking orders, which sought to block different sorts of tweets and accounts, including on controversial issues like the farmers' protests, on journalists' opinions, and much more. The Karnataka High Court has totally junked the petition and basically called it frivolous litigation, upholding the government's censorship efforts online. There were various points to the judgment that we'll go through first, and then Nikhil will tell us more about what he thinks about the judgment as well. So up first, the Karnataka High Court, which was specific in this case was presided over by Justice Krishna S. Dikshit, held that Section 69A not only allows the government to block tweets, but entire accounts as well. As you may remember, Twitter had argued that blocking accounts really infringes on free speech rights because it prevents someone from actually talking in the future as opposed to what they're saying just now. Twitter had also argued that the orders lacked reasoning and showed a non-application of mind by the Indian government in the sense that they were frivolous. And the Karnataka High Court held that they were legitimate and had serious reasoning behind them. And what they've cited in the judgment is various tweets that say suggested during the farmers' protests that a genocide was underway against certain communities in the country. The government also argued in its pleadings that it doesn't necessarily need to inform users that their accounts are going to be blocked. And it said that doing so would actually lead to a security issue because people would know and then they try and maybe spread the misinformation, quote unquote, more. And that's a stance that the court upheld in its verdict as well. And the court also held that the government's orders weren't disproportionate. In fact, they were legitimate in trying to restrict the speech that they did. And that Twitter's case in this thing that they were essentially infringing on speech in a very broad-based and overbearing way was wrong. Twitter had also asked the Karnataka High Court to frame guidelines curtailing how the government issues Section 69A orders, and the court declined to do so, saying that that was actually an executive function, and repeatedly across the judgment said that everything in this case was a matter of policy that the court cannot interfere with. Finally, the court fined Twitter 50 lakh, calling the entire case frivolous litigation, saying that it has essentially clogged up the system and harmed the interests of various other litigants who are trying to clear their cases as well. So that's just a summary of everything that's happened over the last year. This was filed last July. The judgment came a few days ago. And I'd love to hear from Nikhil your initial thoughts on this and how this impacts not just speech, but censorship in India as well.
Yeah, so one of the points that I made initially when this case was filed was that, and even when during the farmer protests, when accounts were being blocked left, right, and center, that blocking of accounts is a very different thing from blocking speech as such, right? Or blocking a particular speech. So, for example, if someone's talking about, genocide being committed, blocking that tweet or even putting it, let's say, in suspension for a limited period of time is very different from blocking it forever, because that just means that you're not only preventing current speech, and which may be problematic, but you're also foreclosing the option of future speech. And therefore that's a disproportionate act of censorship, because how do you know whether what I'm going to be saying later on in the future is going to be legal or illegal speech? So effectively, what the government has given itself the power to, and what the court seems to have reiterated, is that the government basically has the ability to shut anyone up if they don't like what they're saying. And some of it may not be legal, but effectively they're assuming everything in the future is also going to be illegal, which I think is a wrong approach to take here. Yes, there are also repeat offenders and people who may repeatedly do it, and there needs to be a rational approach to it. What we also found was that, for example, during the farmer protests, that there were tweets by members of parliament that were blocked. So this argument that you don't necessarily need to give an individual a hearing, and the court upholding it, I think is frankly something I completely disagree with. Because what happens is that, if my tweet is being censored, don't I have the right to go and participate in this process? Because effectively, I'm the creator of that content. I'm the one who's being censored. The platform is merely a conduit. I'm using the platform to publish. So only in circumstances where the individual cannot be identified should, or in case of emergency situations, should the government be allowed to censor content, because otherwise they can just censor whoever they want, and the person really won't even know that their content is being censored, because this is secret government blocking. Like Section 69A, the rules allow essentially ensure that a party who's being censored is not informed that they're being censored. And my conversations with people about why this rule came about was that, for example, that it is in order to protect a complainant, not to basically keep the censored person in dark. So to that extent, I think this is, I completely disagree with the court's approach on it. In fact, even in the Shreya single judgment, I remember distinctly, and I felt that the Supreme Court also should have done so much more in terms of upholding free speech, especially in case of Section 69A. They said that it's literally, the thing, the phrasing is that if like, while there is a due process available under Section 69A, where it says, of course, if the creator of the content is identified, then of course they should be given a hearing. So I don't think that comes across as a mere suggestion or it's an optional thing. But we found that the government is usually issuing orders and not giving an individual who's been censored a hearing. They're only issuing these diktats to the platforms. Now, the other thing that happened, if you remember the issues that came to light around that time, when some of the communication between the government and Twitter was leaked, Twitter had actually argued with the government that some of the censorship that was being pushed was actually violative of the fundamental rights of free speech in India, as in the content itself was not illegal. Now, effectively, you're right, Twitter, the court is right, Twitter is not an aggrieved party who's being censored over here. But in a situation where a person doesn't even know that they're being censored because the rule prevents them from being informed about censorship, how are they going to protect their own, go to court to get their fundamental rights protected? So either you give them a hearing, or you allow Twitter to argue that these are basically censorship of free speech. Yes, Twitter doesn't have rights to free speech, but we do. So I think this is a problem. So proportionality is clearly an issue here, and I think the court should have definitely done more. I completely disagree with the court in the fact that they say that censoring an account is not proportionate, is not disproportionate. I don't know if they've addressed a particular aspect, and maybe you can tell me about it from the judgment. But one of the points of conversation also came up was that when you censor something on the basis of public order, there has to be a rational nexus between what is being said, and effectively it should be incitement to violence and actions on the ground. So where there was no public disorder as such, in that case, why was censorship happening? So when there's no rational nexus, then why is it that content, which is just critical, because let's not forget that journalist accounts are also being censored. I know Twitter's filed this case with respect to 39 complaints only, but I think we need a policy overall over here, and I don't think the government is going to do it. So even the court's argument that this is an executive function, in my opinion, is not correct, simply because in the past, when things have been a problem, the courts have stepped in to direct the government in terms of what they can and cannot do, and they have read the law, and in the Supreme Court's case, they have read into the law what a proportionate approach should be, or what a approach that protects fundamental rights should be. In this case, the court could have easily read the fact that in this order, any information only includes information in the past and not information in the future. That's one reading that they could have done. Another thing that they could have done is that they could have taken the Supreme Court's approach and enforced the fact that users need to be informed. So I think that's just my initial thoughts on what I've heard you say. But is there anything else that maybe I've not covered?
So what's interesting about the account level blocking is the court actually goes on to cite Twitter's banning of Donald Trump
Hmm?
as an example of how in extreme situations an level blocking isn't really that bad of a decision. So they've kind of used a bit of a reverse googly on the platform itself to justify, I mean, not justify, but to kind of support the argument that it's making.
But the
As
ban on Donald Trump's account has now been removed, right? So there was
exactly,
effectively the court can also view it as a time block. Maybe that
exactly,
time was a long period of time. Secondly, the requirement to protect fundamental rights is not Twitter's; it is that of the courts.
exactly,
Our fundamental rights protect us from the government, not from Twitter. So as a
exactly.
private platform, they can censor who they want, but as a public entity, we need greater accountability from the government.
Exactly. And coming to the point you'd made, and you asked about the rational nexus, whether the court had really delved into whether the orders had a reason behind them. If you look at the very minute parts of the orders that they've reproduced, they talk about the fact that these are anti-national, they're spreading misinformation during the farmers' protests, and then this could lead to a public order situation. And then, of course, the comments on genocide that I mentioned earlier, which were termed as mischievous. Um, and I think there's an issue there in the sense that all of this is coming to the court in a sealed cover. Apparently, they were submitting hundreds of pages of different kinds of descriptions of tweets, which none of us have access to. So it's very hard to say that, oh, yes, there was a rational nexus that the court identified because the court identified it, but we have no insight into what that nexus was. And I think that's a larger issue with the confidentiality and the total lack of public transparency that we have over how these blockings
No,
happen.
I mean, in my opinion, the court should have used this opportunity to bring transparency to the situation because
Yeah,
that's the problem with Section 69A. And effectively, it is difficult for us to make. There were tweets that were also shared, for example, in the Lumen database. So we know what kind of tweets were being censored. We just don't know which are the tweets that Twitter used in order to file this case.
right,
That's not in the public domain. And the court could have used this opportunity to make those public because, frankly, I think there's a flaw in the rules which are being created by the executive and not by parliament, right?
right,
Where that allow for secrecy here. And so
right,
the court had every right to overrule them because it's not overruling an act of parliament, it's overruling an action from an executive.
right. And I actually wanted to bring this back because you mentioned the fact. So, like, if you look at the court's justification and the evidence it cites, it seems so natural that there's this rational nexus between the actions and the output. But this is something that you had mentioned when the challenge was filed last year, that Twitter actually limited itself by just restricting itself to challenging 39 tweets. It could have actually done more and challenged the law itself. And I think in this case, you might have been right, because if you look at some of the arguments that were made based on the information that we have, um, it seems as if they focused on one moment in time when there are so many instances where Section 69A blockings have been totally off the mark, whether it's Tanul Thakur or anything else. So do you
Yeah,
think
sorry, go on, go on, go on.
so do you think that, 1 year later, would you still agree with that opinion that you made?
Yeah, I think so. I think Twitter's failed us, and I said it then as well. They should have
Yeah,
done so much more. And frankly, you know, they had the opportunity because they have more access to information than any of us do. And I frankly don't know. One other thing that I wish that they had done was challenge the usage of emergency powers because frankly, emergency powers are being used in almost every single instance to block. That's what we hear on the street, and we don't have public information. But when you talk to folks in public policy, they tell you that most of these orders that are coming through are emergency power orders. And so, is everything an emergency, right? How do you define an emergency situation? Why aren't courts taking this opportunity to ring fence the emergency situation? Because in an emergency situation, the orders issued first and the committee meets later. Whereas if let's say 80+% of orders are emergency orders, and maybe it's more, maybe it's less, I don't know. But we know it's a large number. If most of the orders are emergency powers, then are we always in an emergency situation,
right,
right? And so that's also a point of exploration and a point of challenge because effectively that also means that the user that is affected or the affected party doesn't get heard. And if you
Right.
look at it, right, uh, the same rules were being used for the app ban in case of the Chinese apps.
Right.
At that point in time, none of these companies were given the hearing, a hearing. I don't think they've still been given a hearing by the committee, but for purely political reasons, which is that India wanted to probably give one back to China. Those bans were instituted, um, and they're still there. They haven't gone to court to challenge the orders, and I think that's their fault. But because you're going against a state machinery that is got far more power than the average citizen. I
Right.
think, frankly, this calls for someone to take this judgment, and I don't know if Twitter will, but I don't know. I'm not a lawyer, but I don't know if a citizen can take this judgment, or an affected party can take this judgment and essentially go to court on this issue, right?
Right.
So we don't know how this is going to play out.
Right. And I mean, I just had a question because we hear this in public policy a lot that, national security, misinformation, anti-national, these are very vaguely defined, overbroad. It has censorship consequences. My question always as a layperson is what is the alternative? When we're talking about Section 69A, we're talking about a policy overhaul. How do you define legitimate grounds for content blocking in this day and age?
Well, national security is still not defined in law.
Right.
Uh, Public order, I think, has been defined via courts, but it looks like other courts don't really take them into account. Proportionality invariably is ignored by courts from what we can see in
Right.
many judgments. So, I don't know how what we can do, but I think there needs to be an overhaul of our surveillance systems, of our regulatory systems to to restrict the actions of the government a lot more, because right now it looks like a free for all. They can
Right.
censor what they want, and with the IT rules, which again Twitter chose not to challenge,
Right.
they've got disproportionate power of censorship. And because an employee of a social network can go to jail, none of the social networks are essentially going to take the risk
Right.
of deciding not to censor something,
Right.
even on the basis of a user complaint. So
Right.
effectively, it's kind of undoing the guardrails that, to some extent, the Supreme Court had placed um, in Section 79, which was basically blocking in case of a user complaint.
Right.
Uh, so there are several changes that have taken place that look like they're going to undo the work and the great judgment that we had in the Shreya Singhal case. Um, and I think Twitter's sort of Twitter's missed a trick here, and B, I think the court uh, hasn't really done justice to towards addressing the disproportionate power of the government here.
Right. And I just have one last question. So you mentioned the IT rules, and of course, we have this fact check amendment that's coming and is now stalled. And we have three different cases before the Bombay High Court. Do you see this verdict having any bearing on that fact check amendment or the challenges against it currently?
I don't think so, to be honest, because that's a different challenge. Twitter didn't challenge the rules here.
Right.
And I think that also different courts at times have a different approach towards things.
Right.
And so I know this is a single bench judgment. I hope Twitter appeals. My guess is Twitter is not going to take that next step of either appealing to a division bench or going to the Supreme Court with this.
Hmm.
But someone, it's just that someone needs to do something about this situation, to be honest, because we're heading into an election year,
Right.
and with this fact check amendment, with these restrictions and the opacity around Section 69A, you might see a lot of political speech being censored. We looked at the Press Information Bureau's fact check handle
Right.
prior to the discussion on this amendment, and so much of their commentary was political in nature.
Right.
So one, government certifying fact checkers, I think, is a problem. Government determining who can be a fact checker, who can't be, is a problem. And I think this government taking on the role of fact checking itself is also a problem. I don't think the government is in the best position to fact check itself. And I know Rajiv Chandrasekhar, the Minister of State for IT, has gone and said that the government has best access to information. And
Yes.
so, therefore, if someone's reported something incorrectly, they are in the best position to correct those facts. I think that's actually indicative of a bigger flaw, because frankly the same information should be available to the public as well.
Exactly.
And so it's leveraging the secrecy and opacity that the government gives itself, which gives itself power, and then using that as an argument to suppress perhaps what might be the truth, right? And journalists are supposed to report the inconvenient truth. And in that sense, free speech is allowed us, like a fundamental right to free speech. The primary function is to allow us as citizens also to voice an inconvenient truth.
Right.
What Section 69A does, and what upholding Section 69A and upholding these potentially problematic orders does, that it limits, it restricts, it diminishes our fundamental right to free speech. And it only emboldens the government in terms of censorship going forward. So pretty bleak, frankly, from what we're seeing here. And I'm extremely disappointed that the government didn't take this, that the court didn't take this opportunity to basically take another look at the rules, the regulations, 69A, and these specific orders, in light of, not in terms of what the intention of the law is, but what the intention of giving us of us having the fundamental right to free speech is. So I would say that it should perhaps have looked at a higher threshold than just rules, frankly.
Right. And it's interesting because if you look at the entire judgment, there are so many comments on Twitter's non-compliance with the blocking orders, its tardy conduct, and the court has justified it in its own way. But I mean, the restrictions on on free speech, or even just talking about free speech as a right, it takes up such little space in the judgment. Twitter gets yelled at a lot in the judgment. You also have a lot of commentary on how bad social media can be for democracy, how it can destabilize nations. But the question of speech and why it's important for nations really takes the back seat in many ways.
In
So
that sense, and in that sense, I think, Twitter. Sorry, what is the last point that you just made again? Could you repeat that?
I said that speech takes a back seat in the judgment. There are a lot of paragraphs essentially talking about how bad social media can
Right.
be.
So what happens is, with this 50 lakh fine also being imposed, what it does is that it has a chilling effect on anyone going to court now
Right,
on these issues, and
right,
that's also not good for free speech.
right. And I just had one more question, and this is something that I know we've discussed a lot at Media Nama, which is the identification of practically every user of the Indian internet. And if you look at the government's pleadings before the court last year, something that they noted that was interesting is that harmful speech often comes from anonymous accounts. It's difficult to detect who they are. And even in this judgment as well, they talk about how people may even use the garb of anonymity to spread more and more misinformation or inflammatory speech. So do you also see this as a kind of reckoning moment, perhaps, for anonymity on the internet and the kind of freedom that speech has as well?
Well, this is not the only instance where anonymity has been highlighted, and it's a part of the state's argument, right? We've had functionaries of the BJP, which is currently the political party in power and government. We've had functionaries from there repeatedly talking about Aadhaar authenticating social media accounts.
Right.
So this push against anonymity is not new. There are instances, for example, related to terrorism. There are instances related to child sexual abuse, of harassment of women. And there is this constant demand for verification and identification of individuals. And one of the conversations that we had at Media Nama a few months ago was around bringing proportionality into authentication and verification, and leaving room for anonymity, leaving room for pseudonymity, because that's also a critical part of free speech. And the other part is that what good has verification done in terms of identifying people anyway? Because you look at the amount of spam and scam, and telecom operators have this system called Astra, which we reported on, which does facial recognition of people who are signing up for mobile numbers. And they're supposed to take an ID. A large part of mobile number signups are taking place using Aadhaar. None of that's really helped prevent crime there, right? So if you're saying that anonymity gives people power to let's say break the law, I don't think verification has changed anything there in case of mobile phones anyway.
Right.
So I think it's a flawed argument. The evidence stacks up against it. What it does do is that it basically puts us under surveillance all the time, and that's a violation of the fundamental right to free speech, because you have to take into account proportionality there. Sorry, violation of our fundamental right to privacy. So one of the things that came up in that discussion was that courts just aren't considering proportionality anymore. They're not considering proportionality in internet shutdowns. They're not taking it into account very clearly in case of free speech. They don't seem to be taking it into account in case of privacy either. And that's disappointing, because I would expect that courts should, and our learned judges should, have that nuance in terms of dealing with issues related to fundamental rights, because the reasonable restrictions that we have to our rights should not become the cause for expansion of restrictions, and therefore the restrictions shouldn't become unreasonable. That test of reasonability doesn't seem to be something that our courts seem to be taking into account.
Exactly. It's, as one of the speakers said, it's like a question of punting the case on to the next Chief Justice or the next bench that comes in. And we're also coming up to the 1-year anniversary since the last hearing in the Pegasus case, which speaks for itself.
And the one thing I remember from sitting in for most of those hearings was Justice Ramana saying repeatedly that we don't want to question the government on issues of national security. And I'm sitting there thinking, why not?
Yeah.
National security that phrase shouldn't basically give the government a free run to do whatever they want. It's an easy out for them then in every instance.
Exactly. So do you have anything else that you'd like to share on the judgment? Any final thoughts?
I think my only hope is that someone goes and challenges the government on Section 69A. There are a host of cases related to the IT rules already in the Supreme Court.
Yes.
And I think it's about time we heard some of them and address some of the areas that the Shreya Singhal judgment failed to address.
Here's hoping. So thank you so much, Nikhil, for joining us. We have a blow-by-blow coverage of Twitter's pleadings, the union government's pleadings, and practically every hearing in the case on the Media Nama website. So do check it out. And